About KAS 2017 polity questions. Now we will be discussing KAS 2020 polity questions. According to Article 236A of the Indian Constitution, the expression district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small KAS court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, and assistant sessions judge. So which of the following options below are correct? See, according to Article 236 of the Constitution, the district judge, they are the judges of subordinate courts. So Indian Constitution, it has adopted integrated judiciary headed by Supreme Court. Below that we have high courts of the states, and below that we have the subordinate courts. So district courts, they come under the subordinate courts. Now according to Article 236 of the Constitution, the district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small KAS court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, and assistant sessions judge, and additional sessions judge. So as per this definition, all of the above comes under the definition of district judge. Next question. The National Development Council was established in March 1952, June 1952, August 1952, and October 1952. So the National Development Council was set up on 6th August 1952. So third is the correct option. To strengthen and mobilize the effort and resources of the nation in support of 5-year plans. See, once India got independence, for the socio-economic development of the nation, the Planning Commission was set up, and it came up with the concept of 5-year plans for the sectoral development of the nation. Means the importance was given to particular agriculture, manufacturing, as well as service sectors, sectoral as well as regional development. So in order to carry that sectoral and regional development, the 5-year plans were introduced starting from 1952. Okay, so these 5-year plans, they were done by the Planning Commission, but the National Development Council acted as a think tank to support the Planning Commission in order to strengthen and mobilize the effort as well as augment the resources of the nation, and to ensure the balanced and rapid development of all parts of the country. So National Development Council, NDC, as well as the Planning Commission, they went hand in hand in order to present the 5-year plans. So this NDC was set up in August 1952. Now the Planning Commission was replaced by Niti Aayog in 2014. And also there was a proposal to scrap National Development Council, but as of today no such step has been taken. So the NDC remains intact, and it has been merged with Niti Aayog. One can say it has been merged with Niti Aayog. It remains intact, but anyway it has not been abolished. Next, consider the following pairs of committees. Once again, the committees and their mandate, why they were set up, which were in news recently. So in 2020 paper, it was in news recently. It is more of a current affairs related question rather than a polity question. UK Sinha, transfer of surplus reserves from SEBI to the government. Nandan Nilekani, deepening of digital payments. Bimal Jalan, economic capital framework. So out of this, only these two are correct, because In order to understand these structural bottlenecks, that is the problems and factors affecting the performance of MSMEs. MSMEs means micro, small and medium enterprises. RBI had set up an expert committee on MSMEs under the chairmanship of UK Sinha. So UK Sinha is related to Committee on MSMEs. The transfer of surplus reserves from SEBI to the government. This committee was headed by once again Bimal Jalan. So this is wrong. Now coming to Nandan Nilekani. High level committee chaired by Nandan Nilekani on deepening of digital payments submitted its report to the RBI on May 17th, 2019. Digital payments, as we all know, UPI, Unified Payment Interface, BMAP, in order to deepen the digital payments in the country. Deepening of digital payments reduces the amount of generation of black money because the payments will be accounted. The committee was set up with the vision of encouraging digitization of payments and enhancing financial inclusion through digitization. The Reserve Bank of India, in consultation with, so this is correct, Nandan Nilekani, central government constituted a committee once again under Bimal Jalan to review the current economic capital framework in November 2018. So, economic capital framework, Bimal Jalan. Again, transfer of surplus reserves from SEBI to the government, even it was set up under Bimal Jalan. So, this is wrong. Only these two are correctly matched. Hence, the option is B. So, it is very important either for UPSC as well as KPSC to remember the recent committees set up and why they were actually set up. It is important for the aspirants to know. 124th Constitutional Amendment Bill 2019 pertains to merging of nationalized banks, scrapping the special status of Jammu and Kashmir, that is Article 370, same-sex marriage, reservation for economically weaker sections, in government jobs and education. So, this is correct. That is providing reservation for economically weaker sections in government jobs and reservations. So, the 124th Constitutional Amendment Bill 2019 was passed in January 2019. It deals with economically weaker section reservation, that is EWS criteria. Once the bill was passed and it entered into force on 14th January 2019, it is the 103rd Constitutional Amendment Act, that is EWS reservation. So, it amended Article 15 and 16 and the new clauses Article 15(6) and Article 16(6) was added by the amendment. So, Article 15(6) deals with providing 10% reservation in government schools or government educational institutions as well as private, both aided as well as unaided educational institutions for economically weaker sections of the society. Anyway, minority educational institutions, they are not included under this economically weaker section criteria. And Article 16(6) was 16 of 6 subclause 6 was added in order to provide for reservation in government jobs for economically weaker sections. So, the correct one is the fourth one. Next, the total number of ministers, including the prime ministers, here ministers in the sense council of ministers, including the prime ministers, shall not exceed 15% of the total number of members of the House of the People. House of the People means Lok Sabha. Choose the correct answer with respect to this statement. It was inserted into Article 75 through Clause 1A by the 91st Constitutional Amendment Act of 2003. It was inserted into Article 57 of the Indian Constitution by 83rd Constitutional Amendment Act by 2000. It was inserted into Article 61 by 93rd Constitutional Amendment Act of 2005. It was inserted into Article 83 of the Indian Constitution by Constitutional Amendment Act of 1976. So here it was inserted into Article 75 of the Indian Constitution through Clause 1A by the 91st Constitutional Amendment Act of 2003. So here, according to Article 74, there will be Council of Ministers headed by Prime Minister in order to aid and advise the President in carrying out the government, okay, or in carrying out the tasks. So according to Article 74, there will be Council of Ministers headed by the Prime Ministers to aid and advise the President. Now according to Article 75, the Prime Minister is appointed by the President and the other Council of Ministers are appointed by the President based on the advice of or on the recommendation of the Prime Minister. Now according to the 91st Constitutional Amendment Act of 2003, a new clause was added, that is Clause 1A to Article 75, which states that the total number of Council of Ministers, including the Prime Minister, shall not exceed 15% of the total number of members of the Lok Sabha. So this is the correct answer. Next question. The violation of rights and immunities, that is rights and immunities in the sense parliamentary privileges. Of the members of parliament or disrespect to them is punishable under the Act of Parliament. In this case, what motion is moved and under which rule? Is it guillotine motion, privilege motion, censure and cut motion, call attention motion? So the parliamentary privileges, they can be individual privileges given to the members of the parliament or the collective privileges given to the members of a house, be it Lok Sabha or the Rajya Sabha. So these parliamentary privileges, when they are affected or when they are breached, that is violated, then the violation of the rights and immunities of the MPs, they can be the violation, it can be punished under the Act of the Parliament. But in order to do such things, the motion will be called in the Parliament. So which is that motion? So here it is, as the name itself suggests, it is a privilege motion. The privilege motion will be called as per Chapter 20 of the Lok Sabha Rule Book and Rule 187 of Chapter 16 of the Rajya Sabha Rule Book. So based on these rule book procedures, privilege motion will be called if there is any violation of rights and immunities of the members of the Parliament or of the whole house in general. So privilege motion is the correct answer. Next question. Match list 1 with list 2. Here they have given the authors and here they have given the book names. Here also we have to try luck because no one will be knowing which authors have written all the respective books. So here we can try for elimination. Mohit Bhattacharya, he has written books on public administration. If any student had taken public administration as optional in the previous KPSCs or has taken public administration optional for UPSC, they will be certainly knowing Mohit Bhattacharya has written public administration book. So here C for 1. So that is C1, we have two options here. Now, Granville Austin, if we have read the polity books, we will be knowing he is a constitutional expert. So he has given his opinions on many matters like federalism, secularism, or the preamble, like that. So he has commented on working of the Indian Constitution. Hence he has written a book, Working a Democratic Constitution, Indian Experience. So he is a constitutional expert. Hence we can match Granville Austin to 3, that is Working a Democratic Constitution, Indian Experience. Now D goes for 3. Out of these 2 we have only this one. So this is the correct option. Now the A is to Rajni Kothari, Caste and Politics in India. C.P. Bhambri, he has written The Indian State. So this is the correct answer. Who described the Indian Constitution as quasi-federal? The center-state relation. This is nothing but federalism. Okay. So quasi-federal in the sense it is not completely federal. So who described the Indian Constitution as not completely federal, that is quasi-federal? Jennings, K.C. Weir, Morris Jones, Dr. B.R. Ambedkar. So here K.C. Weir, he described the Indian Constitution as quasi-federal because even though the states are sovereign in their prescribed legislative field and their executive power is coextensive with their legislative powers. That is, though center is made power, center and the states, India is a union of states, but the states are also having coextensive powers in case of legislation as well as executive. Okay, so each state will be having its own executive, that is the governor, chief minister and the council of ministers, and also every state government can make its own laws in their state legislative assemblies. Okay, so in that context, both the center as well as the states, they have coexisting powers in legislative as well as executive fields. Now, even though they have the coextensive powers, it is clear that the powers of the states are not coordinate with the union. That means, even though both are having the coextensive powers, the states are not completely so strong as the center, because in many cases, just like for example, in case of emergency provisions or in case of making laws, certain laws which only the parliament can make and not the state legislature. For example, changing the boundaries of the states. Even though the states' boundaries will be changed, the state legislatures cannot pass any law on changing their state boundaries. That has to be done by the parliament. So, coming to the emergency provisions, the states cannot declare emergency on their own. The country or the central government the parliament has to declare the emergency, be it the national emergency or the president's rule in a particular state or the financial emergency. So, likewise, in many matters or in many contexts, the union, that is the center, is having more power when compared to the states. So, because of this justification, K.C. Weir, he described the Indian Constitution as not completely federal, but it is quasi-federal. Next one, the Nirbhaya gang rape and murder convicts. Nirbhaya gang rape case 2012. The Nirbhaya gang rape and murder convicts filed mercy petition with the President of India by using the constitutional provision of the sentence is a sentence of death. As per which article of the Constitution did the President reject the petition? In the last session, while explaining death sentence, I had told the Article 72 of the Constitution deals with the pardoning power of the President. So it deals with the death sentence, pardoning of the death sentence. So here in Nirbhaya gang rape case, under Article 72, the murder convicts, they filed for mercy petition through Ministry of Home Affairs. For any death sentence, the mercy petition will be sent to the President by the Ministry of Home Affairs. The President may consider the proposal. He can commute, reprieve or respite the death sentence, or he may reject the death sentence mercy petition. Okay. In this case also the President rejected, and the 4 murder convicts, they were hanged to death in 2019. Now through Ministry of Home Affairs, the mercy petition will be sent to the President, and President under Article 72, that is pardoning power of the President, he can as I told, he can cancel the death sentence, he can commute, that is reduce the duration of the sentence, or he can change the nature of the sentence, or he can acquit the convicts, or he can reject the death sentence. Now under Article 72, President did so, that is the pardoning power of the President deals with Article 72. So in this case the mercy petition was rejected and the 4 convicts, they were hanged. Liberal political parties aim at. This question is based on ideologies of the political parties. What does liberal political parties do? Reforming the existing institutions, establishing, overthrowing order by existing new the institution, establishing new institutions by overthrowing the existing, establishing new order by overthrowing the existing institutions. Okay, so this is establishing new order by overthrowing the existing institutions. So there is a shuffle of words. Believing in the status quo. Status quo means whatever present it is there, let it be. Okay. Clinging to the old socio-economic and political institutions. So they will be having old beliefs. So liberal political parties, what they do? So liberal political parties, they try to reform the existing institutions. Okay, so the political parties in modern political system, there are 4 types of political parties. The reactionary political parties, what they do? They believe in old political and socio-economic systems. Okay, so they try to even though the society is modern, they try to change it to the old political and socio-economic system, that is reactionary political parties. Conservative political parties, what they do? They believing in maintaining the status quo. So let it be. How it is working on, let it go in the same way. Liberal political parties, what they do? They believe in reforming the existing system gradually, not overnight, gradually. Radical parties, they believe in changing the system very quickly and drastically. So that is the difference between these two. They reform the system gradually, whereas radical parties, they want to change the system very quickly and drastically, that is overnight, sometimes even by overthrowing the existing institutions. Okay, so radical parties are called leftist, liberal as centrist, and conservative and reactionaries as rightist. We have heard leftist party and rightist party. So the radical parties are called leftist parties. They will be having leftist ideologies. Conservative and reactionaries will be having rightist parties, whereas liberals will be centrist. Next question. Which of the following ministry has recently announced? As recently in the sense during that time when the exam prelims was coming, announced that time, to set up the Central Consumer Protection Authority. So this is a current affairs related question. Ministry of Agriculture and Farmers Welfare, Ministry of Finance, Ministry of Consumer Affairs, Food and Public Distribution, Ministry of Food Processing Industries. See, the name itself suggests Ministry of Consumer Affairs, Food and Public Distribution, Central Consumer Protection Authority. Okay, so this is the correct answer. The Central Consumer Protection Authority, it was set up in 2019 under Consumer Protection Act of 2019 by Ministry of Consumer Affairs, Food and Public Distribution. Okay, what it does, it regulates the matters. It is a regulatory body headquartered in New Delhi. It regulates the matters relating to violation of rights of consumers, unfair trade practices like adulteration of food, for example, false or misleading advertisements which are prejudicial to the interests of the public and consumers, and to promote and enforce the rights of the consumers. Promotion and enforcement of the rights of the consumers. That will be done by the Central Consumer Protection Authority. It will be headed by a Chief Commissioner and 2 commissioners. It is headquartered in New Delhi, set up in 2019 under Consumer Protection Act 2019. Who among the following was recently appointed as the Director of National Science Foundation of America? Once again, it is a current affairs related question. National Science Foundation of America, it is a US government body which assists research in all non-medical fields, including science and engineering, non-medical fields. So it was Sethuraman Panchanathan. Okay, he is an Indian American born. So he was appointed to the National Science Foundation as the director. Next, which of the following is described as a novel feature of the Indian Constitution? Novel in the sense, the dictionary meaning is new. Fundamental rights, DPSPs, fundamental duties, rights to constitutional remedies. So, DPSP, Dr. B.R. Ambedkar called the Directive Principles of State Policy adopted by the Constitution of Ireland, that is Irish Constitution, as the novel feature of the Indian Constitution. Okay, so these features, these DPSPs, what they do, they help the government in policy making such that the government should keep in mind the DPSPs while making any laws for the socio-economic development of the nation. So they promote socio-economic policies, this Directive Principles of State Policy, and Dr. B.R. Ambedkar, he called these DPSPs as the novel feature of the Indian Constitution. Immigration Bill 2019, proposed by the Ministry of External Affairs in Parliament, will replace which of the following existing act? During that time, the Immigration Bill 2019 was introduced. The bill did not get passed by the Parliament. Now recently, Immigration Bill 2021 has been introduced. In order to replace the Immigration Act 1983. Okay, so the Ministry of External Affairs, it introduced Immigration Bill 2021 at the time during KAS 2020. So this was the bill, but now 2021 bill has been introduced. Okay, that proposes to introduce, that will replace the existing Immigration Act 1983. Even this is passed to replace this Immigration Act 1983. The new bill seeks to ensure the safety and welfare of the Indians in Gulf countries and will replace the current laws under the Act of 1983. The government proposed the said bill in view of a paradigm shift in the nature, pattern, directions and volume of migration over the last 35 years. So as per a recent United Nations report, the Indian migrant laborers are the largest number of migrant laborers in any other nations in the world. Okay, so illegal labor migrants. Okay, so in order to protect the people who migrate to other countries in search of better prospects. So this bill has been introduced because usually the migrant laborers, they will be very much vulnerable. Usually women and the girls, they will be taken under human trafficking, and the other migrant laborers, especially in Gulf countries, they will be subjected to very poor working conditions. Their passport will be many times confiscated by that countries. Then they will be asked to undergo bonded labor or forced labor. So in order to protect these migrant laborers from all such extreme conditions, the Immigration Bill 2021 aims to make the migration of the laborers in a very formal way. Okay, so it allows for only those agencies which are it permits, the Immigration Bill 2021 permits only those agencies which have digitized their records in case of migrant laborers, because nowadays the migrant laborers, they depend on some agents. Those agents, they will not be sending those migrant laborers in a formal route. So because of that, the migrant laborers, once they enter the other countries, they will be exploited. So in order to remove all these loopholes, the Immigration Bill 2021, here in this answer it's 2019, has been introduced in the Parliament. So both the bill, they are mandated to replace the Immigration Act 1983. Next, who appoints the Attorney General of India? Attorney General of India, he is appointed by the President of India on advice of Union Cabinet under Article 76 of the Constitution, and he holds office during the pleasure of the President. He is the highest law officer, we can say, because he is the one who guides the government in case of legal matters. Okay, the Attorney General of India, he is the part of the Union Executive. He is the part of Union Executive, which includes President, Prime Minister and Council of Ministers. So along with this Attorney General, that is AG. Okay, Union Executive means it includes President, Prime Minister, Council of Ministers and Attorney General. Okay, similarly State Executive means it includes Governor, Chief Minister, Council of Ministers and Advocate Generals. So Attorney General under Article 76, he is appointed by the President on advice of the Union Cabinet, but he holds office during the pleasure of the President. He can submit his resignation to the President. So C is the correct answer. In 2016, this is a current affairs related question. In 2016, the West Bengal Assembly had proposed to give West Bengal 3 new names in 3 different languages, that is Bengali, English and Hindi. It was however rejected by the central government. When the West Bengal Assembly sent the proposal, the government rejected. In 2018, the Assembly once again passed a new resolution to give the state a single name which is common or usable in all the 3 languages, that is Bengali, English and Hindi. So which was the proposed single name? It was Bangla. Okay, so in 2018, the West Bengal Assembly passed the resolution unanimously to change the name of the state, that is West Bengal, to Bangla in the 3 most spoken languages of the state, that is Bengali, Hindi and English, and sent the proposal to the Home Ministry. However, the centre has not yet accepted it. Which among the following is not correct about UPSC, Union Public Service Commission? The chairman and members of the commission hold office for a term of 5 years. The president can remove the chairman or any other member. It is a central recruiting agency in India. it is an independent constitutional body. Okay, so articles 315 to 323 deal with UPSC as well as state public service commissions. Okay, so as per these articles, it is a central recruiting agency, it is an independent constitutional body. Then the chairman and members of the UPSC hold office for a term of 6 years or till they attain the age of 65 years, whichever is earlier. Hence, they will be having a term of 6 years and not 5 years, or until they attain the age of 65 years. In case of SPSCs, it is 62 years. In case of UPSC, it is 65 years. Okay, so whichever is earlier. So this option is wrong. The president can remove the chairman or any other member. Even this is correct. It is a central recruiting agency. It is an independent constitutional body. Yes, both UPSC as well as state public service commissions, they are constitutionally set up bodies. So only the option 1 is incorrect. Protection of women from domestic violence is a constitutional right, fundamental right, human right, legal right. So it is not a fundamental right, it is neither a constitutional right because it is not mentioned in the constitution. It is not a human right also because telling it is a human right is very it decreases its dimensions, whereas it is a legal right because it has a legal backup, that is protection of women from domestic violence Act 2005 was passed by the Parliament, and it came into existence or came into being from October 2006. As it has got a statutory backup in the form of a law, the protection of women from domestic violence is a legal right. So it came into existence from October 2006. Okay. So till now we have discussed all polity related questions of all 4 previous year KAS question papers, prelims question papers. So from next session we will be taking some other subject and we will be discussing that respective questions from the KAS for previous 4 years question papers. Okay, thank you.